Welcome to 55 Plus, The Perfect Years, the podcast dedicated to making the most of the golden years. I'm your host, Roy Martinez, and today we're diving into a crucial topic: planning for wills and trusts. As we age, it's essential to think how we want our assets distributed and our wishes honored. A will is a legal document that spells out your intentions after you pass away. It covers everything from who inherits your property to who takes care of any minor children. On the other hand, a trust is a legal entity that holds and manages assets on behalf of your beneficiaries. Trusts can offer advantages like avoiding probate and providing privacy. Creating a will or a trust might seem daunting, but it's a vital step in ensuring peace of mind for you and your loved ones. Start by making a list of your assets and consider who you want to inherit them. Consult with an estate planning attorney to help it navigate the legalities and tailor your plan to your specific needs. Remember, planning for the future isn't just about financial security, it's about preserving your legacy and making sure your loved ones are taken care of. So take that first step today and secure your perfect years for tomorrow. To explore this topic, I've invited Alan Murray of Legacy Assurance Plan to join us here on 55 Plus, The Perfect Years. Alan, welcome and thank you so much for joining us here today, taking time from your very busy schedule to join us. Let's start by you telling us about Legacy Assurance Plan.
Well, Roy, I really appreciate you having me on. And as far as legacy is concerned, it's we've been in business over 41 years now in the estate planning and financial services industry. We have serviced probably more than 45,000 estate plans over 26 states now. And we are a holistic estate planning service. What I say to people, especially when I do larger presentations in front of groups, I'll say I can help everybody in the room. I just can't provide services to everybody. Not everybody needs what we do, but a simple 15, 20-minute sit down with me, and I'll be able to tell you whether we can provide services or not to you.
One of the things that you and I discussed earlier was that walk us through it, as I mentioned in the intro, the differences between a will and a trust and how things work and what the advantages are one versus the other.
Well, the first thing is a lot of people, and the whole reason I got into this business is my mother passed away back in 2008. She had a will, she had powers of attorney, less than a year old. We thought we were good to go. However, it still had to go through the probate process. So, in any event, one of the things I started to realize is that all wills have to be probated. There's no such thing as a will that will avoid probate. And a will is not a legal binding agreement until, or it's not legally binding at all, until a probate judge validates it. So nobody has to follow what your will says. And by the time it's validated, it's the probate judge that's telling everybody how to carry out that will. So in my opinion, it's not a lock solid plan, that's for sure. With a trust, it's a little different. A trust is a federally recognized legal binding agreement between you and your assets. So it has to be followed. It's completely privatized. It avoids probate if it's done correctly. Now, most times, unfortunately, it's not done correctly.
You mentioned earlier in our discussions earlier this week that many attorneys do not necessarily have the knowledge or the experience in dealing with these types of issues, but your particular organization is perfectly geared for this.
Yeah, the American Bar Association states that less than 1% of licensed attorneys are qualified to do an estate plan. Um, and the reason for that is they only take about 6 hours of it in all of law school. Every attorney I've ever spoken to, and I've asked them, and I know quite a few of them, every attorney I've ever spoken to, and I've asked them, why they haven't chose estate planning. I've gotten the same answers. There's just not enough money in estate planning. And realistically, if you do it the correct way, there really isn't much money in estate planning. There's a lot more money in probate, like 3 to 8% of your entire estate. So what happened with our company is back 40 something years ago, 42, 43 years ago, there was a gentleman that had a very successful investment company, and essentially what happened was he went to a local attorney and he knew that he needed to put a plan together. He had a good sized estate. He knew that he had to put a plan together that would avoid probate. So he got a revocable living trust, and through a licensed attorney, local attorney. And when he died, everything went through probate because the trust wasn't done right. So Dick Follett, who is one of the owners of Legacy, and his two sons, it's a family-owned company. Dick Follett promised that he would provide to his investors a service that would be done. The plan would be done right to avoid probate, in the hopes that their children and their heirs would start to invest with us, invest with our sister company after they saw that they didn't have to go through that whole probate process. So we started providing it just to our members, and we got so good at it, and we've gotten some of the best attorneys in the business at it. Out of the 1% that's qualified, I would say maybe 25% of those can make it through our vetting process. They have to be doing this, 60% of their time, and they have to be doing it the right way, where each trust is going to do what they're supposed to do. And, we don't just look through this through the legal lens. We get the best of the best attorneys, but we follow it up with a team of experts that are going to kind of all pull in the same direction, because you're going to sign what's called a letter of engagement that allows all these professionals to talk. Typically, when you're looking at an estate plan, you think of your attorney, your banker, your accountant, your investment advisor, and you think, oh, they know what's best for me to, for my retirement years, or for my estate plan. And the reality is what's right legally may not be right in a tax situation or a financial situation. So by allowing all these professionals to work together as a team for you, you're going to get a holistic approach to your estate plan.
Now, most people think, okay, most people, and I know a number of people that are afraid to even do a will. The fear is, if I do a will, then that means I'm going to die. Well, we're going to die either way, but making a will doesn't speed up the process at all, but it actually makes it so much easier. So when your organization gets involved, you have to also, you know, make a will at the same time, right?
Well, what you have when you do a revocable living trust, if that's the answer, like I said, that's not the answer for everybody. Everybody is different. My estate plan probably would look nothing like your estate plan, Roy. I have twin 17-year-old boys, so I'd have to figure out who was going to raise them and so forth. But the reality is, no two estate plans are going to be alike. It's just like a snowflake. Um, and what I mean by that is, um, the foundation may be the revocable living trust, but there's other pieces to the puzzle. In other words, maybe we use a specialty deed that can be utilized to shield your home against a nursing home. You know, an attorney may not know about that. So when you go to an attorney, that's what you're going to run into. Is you're going to be limited to his knowledge or her knowledge. Like I said, as far as the way we're set up, um, you know, we do a full package. So when we do a revocable living trust, the documents, we call them ancillary documents, that are inside that trust, that all kind of work together. You do have what's called a pour over will. It's not a last will and testament, it's a pour over will. And think of it just like a bucket. You put all your deeded and titled assets inside of it. Everything that overflows gives it direction on where to go. So you know your piece of antique furniture that you want going to one granddaughter or grandson, it can give that direction. And being inside of a revocable living trust, it's the set of instructions for your successor trustee. There's no more executor. It's called a successor trustee that follows through in the same manner an executor would. Um, and it is legally binding. So your successor trustee has to do exactly what's inside that trust, or they can be held criminally liable. I think I told you the other day, Roy, that if anybody ever asked me to be the executor of a will, my answer would be no. I do not want that job because all you're going to do is put a target on your back. Everybody's going to think you're making decisions, and you can only do what that probate judge tells you to do. You've got somebody looking over your shoulder, and you have to ask for permission before you do anything. So, you know, my sisters may have gotten a little upset with the way my brother settled things. He was the executor of my mother's will, and I just kept telling him he's just doing what the probate judge tells him to do. But you know, in a trust with a successor trustee, I'd gladly do that because if my sisters got mad at me, I would just hand them the trust and say, "Hey, I have to do exactly what mom and dad put inside that book, or I can be held criminally liable. So don't get mad at me, get mad at mom and dad, and you're not here anymore for them to argue with." So they just kind of have to accept it. It eliminates a lot of the fighting inside of a family, and I know a lot of people think, "Oh, my family gets along. Oh, there's going to be no fighting." Yeah. Well, I hope so. I really hope so. I've seen it go the other way one too many times to guarantee that. That's for sure.
I've seen it happen so many times. Even like you said, even families that are very close and think that, oh no, we've never fought about anything. It's not a big issue for us. Whatever mom and dad or whoever is the surviving spouse wants to happen, then that's what we're going to abide. But a strange thing happens when that day finally happens, and that parent is now gone, and now you've got a house, you've got cars, you've got all kinds of property and things that we don't even think about beforehand. And everybody says, "Well, I want this and I want that," and all, and before you know it, it's a problem. It's a major league problem.
Well, I can tell you just from my personal standpoint, I served with the Army in Desert Storm. I joined back in the early '90s, or in 1990. In any event, my father served in Korea. He was with the Marine Corps, and we're the only two to serve in my family. And so I just kind of figured, when my mother passed, that flag would come to me because of the connection we had. And it's still not here in my house. And, my father died back in 2000, so I don't think I'm going to see it anytime soon. And you know, they went with a will plan. And like I said, the probate judge probably looked at my brother and said, "Are you the oldest child?" And he said yes. And they said, "Well, you get the flag." And I can't blame my brother for doing what the probate judge told him to do. Um, you know, I guess it doesn't dawn on him that I had that connection with my father and whatever. But in any event, he had to go through 3 weeks of going through probate and missing work, and it cost him to go through the probate process. So I'm fine. I'm at peace with it. But if we had a trust, if my parents had a trust, if that attorney said to my mother when she walked in and said, "I need a will and I need powers of attorney," and he said, "Okay, I can do that," and that was the end of the conversation. I'm pretty sure that's the way it went because that's the way it normally goes. He didn't explain to her, "Hey, this is still going to have to go through probate. Hey, this is going to cost your family 3 to 8% of your entire estate." And he didn't say, "There's a 70% chance they're going to contact me because it's just human nature." We thought, well, my mother trusted him. He knows more than the estate than anybody else. Why not go see him? And like I said, he made the lion's share of the $32,000 that was paid out. In any event, um, getting back to that flag, had my parents had a trust and put it in the trust that my brother gets the flag, I can't get upset with them. I mean, he has to do what my parents' wishes. If it said it has to go to me, I would have that flag on my mantle right now. And, like I said, I can see how that could cause rifts inside a family, and I mean, what's the flag worth really? Value-wise, it's not worth much, but personally to me, emotionally, it's worth more than anything else I got out of the estate. So in any event, like I said, that's the difference, I guess, that a trust can provide and a will can't. It just really can't.
You mentioned something that it always comes up, the powers of attorney. And if I remember correctly, in our conversation earlier, You mentioned that the powers of attorney basically end at the point where that person dies. Is that correct?
Yes. And this is, like I said, we only know what we know. We don't know what we don't know. And that's why I like doing what I do. At least if somebody listens to this and learns something, I feel like I've done my job, whether we provide services or not. To me, I think the durable, and that's the important word, is durable. Durable powers of attorney are the most important document you can have in your estate plan. Whether you do a will or you do a trust or you let the state write your will, because believe me, we all have wills, and it doesn't say you're dying tomorrow, but we all have wills, and they're written by the state before we're even born. I mean, it's any resident of Texas is going by a Texas provided will, and it's what's called intestate succession law. But without those durable powers of attorney, um, you'd be here for that. That's why I think it's the most important document. And what I mean by that, Roy, and what I had said to you the other day is um, a there's two kinds of powers of attorney. You have the durable, which is the one you want, and you have the general, which is the one I don't know why they even make them, to be honest with you. But my mother went to this attorney and she got a general power of attorney. And what general powers of attorney are good for is up until you become incapacitated. Once you become incapacitated, you can no longer I'm sorry, those general powers have no, the general powers of attorney have no power whatsoever anymore. It takes a durable power of attorney to make those long-term decisions. So in my mother's situation, she was a very active woman. She was down here swimming in the Gulf of Mexico with my twin sons. About 2 weeks later, she had a severe stroke. She was completely incapacitated. She couldn't speak. She couldn't feed herself. She couldn't bathe herself. Um, you know, you know, she died 22 days later after that stroke, and we just thank God because she would have hated the other option of having somebody do all that for her. But in that 22 days, we found out the difference between general and durable. And what I mean by that is, like I said, once she was declared incapacitated, the general powers have no power whatsoever anymore. It's going to take a durable power of attorney if she had to go to a rehabilitation or nursing home or something like that. So me and my siblings would have had to stand in front of a living probate judge because there's two kinds of probate, living and death. And living probate consists of two things, guardianship and conservatorship. Typically, they're going to pick the same person to do the guardianship and conservatorship, but sometimes it'll be something like a nurse in a law firm or something like that. There's a movie right now, or been on Netflix for quite a while, called I Care a Lot. If you all watch that, believe me, the first thing you'll do is get durable powers of attorney. But in my mother's case, had she lived, we would have to stand in front of that probate judge, and maybe my brother would have stood up and said, "Well, I would like to be her guardian. I'm her oldest. I was her executor. I'm her general powers of attorney. I would like to be her guardian." Well, what if my sister stood up and said, "Well, I'd like to be her guardian because I'm the oldest female and I'm a nurse and I think I can do a better job." Well, what would happen is, the judge may look at the two of them and say, "Hey, I'm not choosing between two children. I'm going to go ahead and pick a professional guardian." It's a multi-million dollar industry in this country. Like I said, you watch that movie, you'll see what I mean. And then, all the power is gone. You're basically a prisoner in your own skin. So the reason I'm saying I think that's the most important document is because whether you do a will or trust, or you won't be here for that. You're just trying to make it easier for the people you're leaving behind. If if you don't have durable powers of attorney, you become incapacitated, you're going to be a prisoner in your own skin because as a protected person, and that's what you're declared, a protected person, you cannot hold a driver's license, vote, enter into any type of a contract, have unsupervised access to your own financial accounts, choose where you live, or even so much as choose your own doctor. So you can't fight this on your own because you can't sign a contract. You have no access to your own money to pay an attorney. And, like I said, somebody is in control of you. And that would, I could just see, because you could tell with my mother, she knew what was going on. She just couldn't communicate. And like I said, I would have hated to have to look in her eyes, while she's sitting and somebody else is. And now let's say we go and we visit my mother at a nursing home that this professional guardian has chosen, and we don't like the food she's eating or clothes she's wearing or how they're treating her, and we complain, then that guardian can say we're no longer allowed to visit our mother because we're causing a problem. So now we're completely restricted from any communication with our mother, and they can do whatever they want. There's a case, and you can Google this online, in Collin County, Texas, um, about a lady that's in an assisted living unit, and they're about to throw her out on the street because they've spent all of her assets. And they talk about the judge in that county, and how it's kind of corrupt. The good old boys raiding estates, overbilling, and so forth. And then her daughter chimes in. So her daughter wasn't considered or appointed, anyways, as the guardian, because she wouldn't have had anything to complain about. She would have been, and she would have had somebody looking over her shoulder, which would be the court. But the court doesn't look over its own shoulder, unfortunately. So, in any event, like I said, to me, I think that's the most important document you can have, and that's why I'm so passionate about that.
Now, please, we can go on forever in talking this because this is so
Oh, I
fascinating to
could.
me. What I need to know is where can people get in touch with you, and and how soon can, if somebody needs something, how soon can the process begin?
Well, just depending on what a person needs. I'm going to be able to sit down, and I don't mind doing a free consultation with anybody. We can do it virtually. I'm up in the DFW area now. I have a San Antonio phone number, so that's gonna people are gonna think I'm in San Antonio, but I can't drive 5 hours to sit down with you every day. But in any event, yeah, you're more than welcome to reach out to me. I have no problem with that. I will sit down and you know do a free consultation with you. I will tell you there is a probate threshold in the state of Texas, and that probate threshold is $75,000. What that means is if I were to pass away today and I had a will, my will is going to go to a probate judge. The probate judge will look at the will, look at the size of my estate. If my estate is under $75,000, he'll say, let the will do its job. It's called simple probate. It's very easy, very inexpensive. Nobody complains about it. In my opinion, the people that are in that situation, get yourself a will. Make sure you get it notarized and witnessed. Never write on that will. If you're going to want to make changes, just write up a new will and get it notarized and witnessed again. But don't ever write on it because it's gonna make it non-valid once you write on it. Also, durable powers of attorney, which you should have done by an attorney, in my opinion, in the state that you reside. Um, and like I said, I think you're going to be good to go. We can't do that for you because we provide a holistic. We our names on the line that your state doesn't go through probate and that your kids are because we even help the kids settle the estate. It's a membership that we have. But in any event, um, the way they can now, if on the flip side of the coin, if you own a home or you know um, you're over that $75,000, you pass away, your will goes to the probate judge. The probate judge looks at the will, looks at the size of the estate, says it has to go through the whole probate process. That is typically going to take 18 to 24 months in most counties in Texas, and it's going to cost somewhere between 3 to 8% of your entire estate. Now, if there is no will and you're using the state provided will, well, that's going to be the 8% plus, because that's usually the most expensive way to die, because there's no clear intent about what the deceased person wants. So if anybody needs to get a hold of me and needs to, question whether they need to sit down with me for a, you know, a an inter, a free consult, or if they just want a question answered, my cell phone number is 210-740-6136. And I have an email at Legacy. It's A Murray, Murray, at Legacy Assurance Plan, and that's ASSURANCE, assuranceplan.com.
And if they miss that, they can always get in touch with me. Alan, thank
Oh,
you
sure.
again
Sure.
so much for joining us. And that's going to wrap it up. We hope that you enjoyed it and you were able to get some important information to truly enjoy the perfect years. Join us next time for another episode. And remember, getting old is better than the alternative. And it's a privilege that not many people get to enjoy. We'll see you next time on the next episode of 55 Plus, The Perfect Years.